injury, tort litigation, transportation litigation, workers' comp, employment law, premises liability, and products liability. You're having a terrible football year, aren't you?
Oh, the worst. You're talking about Steelers and Auburn, right?
That's right.
Okay.
Go.
Good morning, everybody. It's good to be here again. And I'm proud that the AWCO has asked me for the 6th year in a row to speak to you about the legalization of marijuana, CBD, and its potential impact on the workforce. The first year I spoke about this was 2017. And I was really excited with the issue because it's cutting edge. It's something that to me had boundless possibilities to talk about. And if I was invited to come back in subsequent years, there'd be a whole lot of new developments to talk about. Now, I've spoken on a number of subjects that are important: scheduled injuries, ethics, permanent total disability, all that stuff. They're interesting. Well, they're things we need to know, but they are boring as hell compared to this subject. So every year that I have spoken about this after 2017, I've started my presentation with, there's been a whole lot of developments in legalized marijuana and its impact on the workforce in states across this country. Now, I'll get into more detail in a minute, but the federal government, marijuana in any form is still illegal. It's a Scheduled I drug. With the exception of cannabidiol, which I'll talk about in a minute. But there were 24 states that had legalized marijuana in 2017. Last year, and when I say legalized, some form of legalized marijuana, a lot of them are medical. Last year, there were 37 states that had some form of legalized marijuana. And I was very excited because Alabama was the 37th state. The Hall Compassion Act was signed by Governor Ivey in May of 2021 that made medical marijuana legal for people with qualifying conditions. Now, there hasn't been a lot of change between last year and this year, and that's not because the people, it's not an interesting subject anymore, or it's not important. I think the reason is there's just so many states that have it now that it's slowed down a little bit. There are 9 states right now that have legalized recreational marijuana. And so about 75% of the people in this country live in a state or in an area that has some form of legalized marijuana. Now, what hasn't changed? The federal government's view of marijuana hasn't changed at all. In the 1970 Controlled Substances Act, and that act created 5 different schedules for drugs based on their ability or based on the likelihood of addiction and their medical benefit. Schedule I being the worst, Schedule 5 being the best. Marijuana was and is listed as a Schedule I drug. And a Schedule I drug is one that has absolutely no medical value and is highly likely to be addictive. So you got marijuana on there, and its buddies are heroin, crack, cocaine, all the other baddies that you can think of. Now, Schedule II drugs, those are drugs that have some medical value, but there is still the possibility of or the likelihood of addiction. And those drugs include Adderall, OxyContin, fentanyl, and things of that nature. And of course, we do recognize they have a medical value. But I started thinking about this the other day, and the last 2 states that legalized marijuana were Mississippi and Alabama. I reversed the order, because as everybody knows, Alabama's motto is "Thank God for Mississippi." But then I started thinking about the federal government. Are they not ashamed that they are not as forward thinking as Alabama and Mississippi? You would think, and maybe it will happen, that they will be so ashamed, they'll say, we should have done this decades ago. But let's talk about the law, the medical marijuana law. The Alabama governor signed into law last year. It's the Hall Compassion Act. And that makes medical marijuana available to individuals, including children, with certain qualifying conditions. Now, there is a list of about 15 conditions. The ones that I think are relevant to on-the-job injury claims are the worst one, intractable pain caused by an injury that has not responded to more accepted and conservative treatment options, including OxyContin and oxycodone. And the other two that I think have some relevance are PTSD and depression. Now, the law, it's in effect, it's on the books, but as we sit here today, nobody that has a qualifying condition can get medical marijuana in Alabama, because to put everything into place for the marijuana to be available, red tape and all kinds of things. In fact, the governor created the Alabama Cannabis Commission to run and regulate the program. They started taking applications September 1, 2 months ago, for growers, for processors, for and distributors. And they're only going to have a certain number across the state. I think the growers might be 12, the processors 4, and the distributors 4. And they got 179 applications. So the Cannabis Commission is going to have to decide and approve licenses. And once that happens, the growers can start growing. So right now there's nothing growing. And because of marijuana status federally is illegal, it has to be grown in the state. Everything has to be in the state from seed to sale. So when the Cannabis Commission gives licenses, it's going to take time to grow, it's going to take time to process, and it's going to take time to distribute. So their best estimate is late next year, about a year from now. I would be surprised. I would be surprised if it was in effect at that time. Now, the question for all of us has been, well, what effect will that act have on the job injury claims and on work comp when it goes into effect? Well, first, the Hall Compassion Act does not in any way change any provision or statute in the Alabama Work Comp Act. In fact, the law states very clearly that it does not and will not deprive an employer of all of the defenses that are available in the Work Comp Act. So when it goes into effect, the defenses we will still have is regarding individuals who are injured or killed due to their impairment or intoxication by alcohol or drugs. And it doesn't matter if the drugs are legal or illegal. Just like alcohol, if you think about it, it's legal, but if you hurt yourself because of it, you're not entitled to quote unquote compensation. And that's important because it doesn't apply to medical benefits. So if somebody is injured and they're impaired by drugs, alcohol, and the employer, by the way, has the burden of proving that, which I'll talk about in a second, the employee, the injured worker, is still entitled to reasonable and necessary medical benefits. So that I know that hangs up a lot of people, but an employee that has a post-accident drug screen or alcohol screen pursuant to DOT guidelines, and almost all employers do this, if they test positive for alcohol or drugs of any type, they are under the law conclusively presumed to be impaired. That's legal gobbledygook. What that means is they're impaired as a matter of law. They can't say, well, I went to a party this weekend and people were smoking weed, but I wasn't. Doesn't matter. You are impaired as a matter of law. The employee is. But then the burden shifts to the employer to prove that their injury was caused by their impairment. Most people know that now, the people in this room. I remember about 10, 15 years ago getting a call from someone who said, I just denied this claim. He tested positive for marijuana. And I denied the claim. And I said, well, what? Tell me about the accident. It turned out this guy was on a construction site sawing on a sawhorse. And I said, was he supposed to be there? Yeah. Was he doing anything differently? No. somebody knocked a brick off 3 stories high and hit him on the head. And I said, you can't deny that. I mean, just because he tested positive for marijuana, he wasn't doing anything wrong. The person, took a long time for me to convince the person I was talking to that was the law. But sometimes people will say, well, if they're impaired, we're just denying the claim outright. It's important to remember that we have to prove the impairment caused the injury. With alcohol, that can be easy because alcohol stays in the system a very short period of time. And somebody who blows or a blood or a urine test that shows alcohol, there's a good argument their impairment caused their injury. Marijuana is slow to metabolize out of the system. It can stay in someone's bloodstream up to 30 days after they ingested the marijuana. And there's no test right now to determine if someone's level of marijuana was recent or was 20 days ago or was 30 days ago. So it's harder to prove impairment by medical or any marijuana was the cause of the injury. Now, there are a couple of ways that we do it. One is observations by co-employees. It's important, and I'm sure all of you know that, to immediately investigate the action, talk to the person's coworkers, and if they noticed he was acting differently, he or she acting differently, slobbering, whatever, get their statements right then. Some companies have a reasonable suspicion form, which I have a copy of. If anybody wants a copy, just if you email me, I'd be happy to send it to you. It's a more detailed form that the job site supervisor would fill out for detailed information about exactly what everybody saw and all the boxes you check. And it's important because it's done right away. 2 years from now, if it goes to court, people are going to say, I don't remember what was going on. I mean, I think he was slurred his speech, but I don't know. You have this document. This was taken right after the accident. So that's very important. For work comp, the first issue was the defenses, the defenses stay in place. The second issue that we will be faced with that we don't know about yet is medical marijuana. Is it going to be a reasonable and necessary medical treatment that the employer or the insurance carrier is required to pay? Now, did the Hall Compensation or the Hall Compassion Act discuss that? Not specifically. The Hall Compassion Act was silent on whether employees can treat with can be treated with medical marijuana. The law did not ban employees from being treated with medical marijuana. And doctors, by the way, because medical marijuana is illegal federally, they can't write a prescription for it because they are regulated by the DEA. So they have to refer somebody for it or recommend it. Now, one thing interesting, the law did say this: employers, insurers, health insurance are not required to reimburse anyone for medical marijuana. So it doesn't speak to work comp and it doesn't speak to reasonable and necessary, but it made that statement. I mean, that is the law. And I think whether medical marijuana becomes reasonable and necessary, I think that's going to be fought out, probably over the years once the system is in place where individuals have access to medical marijuana. And I was thinking about that. If Alabama law or the cases say that it is a reasonable and necessary medical benefit, employers are going to say, yeah, okay, we don't have to pay it though. But the Comp Act says the employer insured does have to pay for reasonable and necessary medical expenses. So that might be an issue in years to come, not at this point. But the act does not answer the question for employers: is it reasonable, is it necessary, and do we owe it? What effect does the law have on employers? And I'm talking about just in general, not just work comp. The act is very pro-employer. It puts no new obligations on an employer whatsoever. They're allowed to keep all of their policies in place that they have. They're allowed to have drug-free workforce policies. They're allowed to make new policies that address medical marijuana. they're allowed to fire people that test positive for marijuana, whether it's legal or not. An employer can even have a policy that tells their workers, if you get a cannabis card, you got to tell us, and then they can fire them. So it's not, at least right now, not going to have any effect on employers. That's not a work comp issue, but and there are no protections whatsoever in the act for employees. Employees cannot demand or ask that their employers accommodate the use of their medical marijuana. If, under comp, if somebody has an on-the-job accident and tests positive for marijuana, medical marijuana or otherwise, that's a complete defense in work comp. So the bill is really strongly pro-employer. Now, what's interesting about that is we've all seen that and heard that businesses have a staffing shortage. They're finding it harder and harder to get people that can work for them, qualified people that can work for them. Amazon, for instance, by the way, is very pro medical marijuana, legalizing medical marijuana. And they stopped testing for THC because they had determined that when they did test for it, they lost out on about 30% of their applicants. So they did away with that test, or, as far as employment. Now, if someone's hurt on the job, they still drug test, like everybody should. Another important thing to remember is no matter what Amazon does or any other company that legalizes or doesn't test for marijuana, any of their jobs, like truck driver, trains, shipment, anything that's regulated by the Department of Transportation, they have to follow federal law. So anybody that tests positive for marijuana, if it's legal in a state, it doesn't matter. The Department of Transportation absolutely regulates it. And frankly, don't we care that the people that drive our kids to school or fly in our planes, we don't want them to have marijuana in their system. We don't want to be thinking about, well, was it 28 days ago or was it yesterday? We don't want it. So, will the federal government legalize marijuana? I personally don't think they will, at least not for a long time. But what they might do is reschedule it to a Schedule II or a Schedule III drug. Right now, as a Schedule I drug, it's not FDA approved. The FDA hasn't even done anything to begin the process, trials or anything like that. If it's rescheduled to a Schedule II or a Schedule III drug, that'll open the doors for research and trials and FDA approval and so that we can find out so all of us can find out, employers, businesses, is medical marijuana have a therapeutic benefit and a good replacement for opioids, which have destroyed so many lives. When I started practicing, it was supposedly the next best thing. It was the coming thing in work comp. And of course, you had these doctors that were general practice doctors that had these people on it for 3 years because they said they had back pain. And the fentanyl and opioid crisis, there are people dying every day from that. And I'm not making light of that, but I haven't heard of people overdosing on marijuana ever. And again, I'm not making fun of that, but so that's that's one of the things that's the future of medical marijuana. Now, CMS will not consider the cost of medical marijuana when they're doing a Medicare set aside. Health insurers won't pay for it because it is not FDA approved. Marijuana does not have a billing code or a fee schedule. Now, there is an exception. New Mexico, which was one of the first states, if not the first state, to say legal marijuana is a reasonable and necessary treatment for on-the-job injuries. Marijuana is on their fee schedule, believe it or not. And I looked it up today. It's $11.06 a gram. And I thought, my friends in high school said they pay a lot more than that. They said it was horrible too. You can only imagine what this is, but think of the cost too. How many of you have claims that people are on so many narcotics and pain pumps? You spend a few $1,000s a month. Imagine paying $11. And the injured worker is probably better off. Now, are they going to be able to work under those circumstances? Maybe not, but we get that every day with opioids that, oh, heck, they can't work. They're under the influence of these drugs for their injury. Does anybody have any questions about any of this, any subject whatsoever? It's like I got a little bit more time. You know, there hasn't been, obviously, since medical marijuana has not been passed yet or has not gone into effect, there has not been an Alabama case on it, on legalized medical marijuana. But there have been cases on employees that were injured and they were under the influence of illegal marijuana. And as I've said, it's going to be treated exactly the same way. So I looked at a couple of those cases to see the court's reasoning, because that's how the courts are going to reason cases if someone is impaired by medical marijuana, because the status of marijuana doesn't matter. Because remember, the Hall Act says it is not changing, it is not taking the employer's right to any defense that they are entitled to under the Work Comp Act. Now, one of the cases I read, the employee was working on a machine that was that cleaned pans, and there was something wrong at the top. He had a mitt and it got caught, and his arm was ripped off, and it went to trial, and the guy had tested positive for marijuana, so he was conclusively presumed to be impaired. The employer tried to prove that the impairment caused the injury, but the trial court agreed with the employee. Which, are there any judges here? A lot of these judges used to be plaintiff lawyers, so I don't know if that has anything to do with it, but that got appealed, and the Court of Appeals, what the employer had done is they'd proven that at least the impairment caused part of the injury. There was other factors that led to the injury, and the Alabama Court of Appeals said if impairment by marijuana or any other drug contributes to an injury in any way, the defense applies, and that employee is not entitled to compensation benefits. And I think that's the exact same way we're going to see it treated once medical marijuana becomes legal and people have access to it. Does anybody have any questions? Well, I can't think of anything else to say. I think I've covered it. And frankly, that's because there has been this year, like I said, between last year and this year, there hasn't really been any new developments like there had been in the past. I was told that this is going to be the last year, at least for now, that this topic is going to be included in the agenda, which, I don't know what I'm going to do with this, but now I was told it could be brought back if there are changes, and I understand that. But if you like this topic, send nice emails to the people at the AWCO. Because we all know TV shows that have a cult following that gets canceled, but then people write in and demand, and they end up keeping it. But be nice about it, because I don't want the AWCO to say, all right, we're bringing it back, but he ain't talking about it, because that'll take my fun away and I might be relegated back to ethics. and ethics are important, but I spoke on those for an hour, and ethics are don't wrongfully deny claims.
You're good.
59 and a half minutes. No, I was talking about, speaking about ethics, don't wrongfully deny claims. And I got 59 more minutes. What can we talk about? Let's just throw stuff out there. If nobody has any questions, I've enjoyed speaking with you today. You've been in our state for 2-3 days now. Beautiful weather. It's going to be beautiful weather today. And I hope all of you have a safe ride home and a happy weekend. Thank you.